My dear friends, so this is the paper 2 CA Inter Corporate and Other Laws. This is the fast track revision of RTP for the benefit of the students. Part 1 Amendments for the May 2026 examination. The study material July 2024 edition reprinted August 2025 is applicable for the May 2026 examination. This study material is updated for all amendments till 31st July 2025. All relevant amendments, circulars, and notifications, etc., in the company law part for the period 1st May 2025 to 31st October 2025 are mentioned below. The Companies Act 2013, Chapter 9, Accounts of the Companies, Notification GSR 357E dated 30th May 2025. The central government has amended the Companies Accounts Rules 2014 through the Companies Accounts Second Amendment Rules 2025. Amendment in the Companies Accounts Rules 2014 in rule number 5 for the words letter and figures form AOC. The word letter and figure E form AOC shall be substituted. Right? Accounts of the company AOC should be E form. So E form AOC 1. So it is substituted for that. Please note this point if there is any question possible on this point of amendment. In rule number 8, in sub rule 2, for the words letter figure form AOC2, the word the letter figure E form AOC shall be substituted. So in sub rule 5, in clause 10, after the words and figures Act 2013, the following shall be inserted, namely following with, along with the following details: number of complaints of sexual harassment received in the year, number of complaints disposed of during the year, number of cases pending more than 90 days. So all these should be reported. Please remember this. If there is any question on this, may be possible. After clause 12, the following clause shall be inserted, namely Clause 13, a statement by the company with the respect to the compliance of the provisions relating to the Maternity Benefits Act 1961. Similarly, in clause 12, after sub-rule 1b, the following sub-rule shall be inserted, namely 1c, every company along with the relevant e-form number AOC4, AOC4 CFS, AOC4 XBRL, AOC4 NBFC Ind AS or AOC4 CFS NBFC Ind AS and the respective attachments in the portable document as required shall also file e-form extract of board report, extracts of auditors reports standalone and extract of auditors report consolidated as the case may be. Because wherever there's a financial statements are there in e-form, either it is a consolidated or standalone financial statements, it should be attached, provided that a copy of the signed financial statement duly authenticated as per the section 134 of the act, including board's report, auditor's report, and other documents in portable format shall also be attached with XBRL forms. Just note down these forms if there is any question on these revisions possible. So enforcement date amendment effective from 14th July 2025. The whole law it is page number 913. So salient features are the financial statements of subsidiaries, associates and JV forms. First proviso to subsection 3 read with clause 5. The statement containing in the salient features of the financial statements of the company's subsidiary or subsidiaries, associate company or companies and joint ventures or ventures under the first proviso 2 to the subsection 3 of the Section 129 shall be in Form AOC 1 as per the Rule 5 of the Companies Accounts Rules 2014. Similarly, page 9.36, particulars of the contracts or arrangement with related parties referred to in section 188 subsection 1, that is related parties are transactions in the form AOC 2, and the words were newly inserted in the clause number 10, and clause 13 is newly inserted, and rule 13 is newly inserted, rule 12 1c is newly inserted. So these are the new rules. Just remember the forms and attachments and the AOC numbers. If there is any question possible, you need to just quote these forms in the exam and you need to answer the question. So again, notification GSR 371E dated 6th June 2025. The central government has amended the company's filing of documents forms in extensible business reporting language rules 2015 through the company's filings of documents and forms in extensible business reporting language amendment rules 2025 amendment. In the company's filing of documents and forms in extensible business reporting language rules 2015, in rule 3 after sub rule 1 the following sub rule shall be inserted, namely 1A, the companies which have filed their financial statements under sub rule 1 shall also attach a copy of signed financial statements duly authenticated as specified in section 134 of the act, including the board's report, auditor's report and other documents in PDF format in e form AOC 4 XBRL. Please note down, my friends, under 134 of the section, including the board director's report, auditor's report and other documents, PDF in e form AOC 4 XBRL. So if there is any question on this also possible on this amendment. So going forward, amendment effective from 14 July 2025, World Rule 31A is newly inserted, and Chapter 10 Audit and Auditors Notification GSR 359E dated 30th May 2025. The central government has amended the Companies Audit and Auditors Rule 2014 through the Companies Audit and Auditors Amendment Rule 2025. In Rule 13, in Sub Rule 2, for Clause D, the following shall be substituted, namely D. The report shall be filled electronically in Form ADT4. Clause E and F shall be omitted. Okay, just note this point. At the same time, amendment effective from 14 July 2025. So this was page number 1035. The report shall be sent to the Secretary, Ministry of Corporate Affairs in a sealed cover by registered post with the acknowledgement due or by speed post followed by an email in confirmation of the same. Page number 1035, 10.38. The report shall be on the letterhead of the auditor containing the postal address, email address and contact telephone number or mobile number and be signed by auditors with his seal and shall indicate his membership number, and the report shall be in the form of statement as specified in Form ADT4. Okay. Following on, we will see now MCQs. So these are the most important section, and where there is a possibility that similar kind of MCQs they will ask with different names, or same MCQs also may occur in the examination paper. So be careful about all these things and be sensible about these MCQs. So let's start question and answers. The case scenario 1, Utkarsh, a brilliant student who has pursuing the degree course in pharmacy at Modern College of Pharmacy, Bengaluru, has inspired and motivated to install and produce a generic medicine Keeping in view his revision, he underwent a 12 months training course in a famous pharmaceutical company at Pune, thereby learnt essential medical formula which were essential in the production of generic medicines. Okay, to convert this vision in reality, he constantly thought of establishing his very own company, and the same he did by incorporating a pharmaceutical company which went by name Woodco's Pharmaceutical Private Limited, one person company with registered office at New Delhi, having 40 lakhs as authorized share capital. As an essential requirement to designate a nominee for his one person company, Woodcock requested to his elder brother Yashwant, who was a doctor in general medicine, to seek his consent for becoming nominee, on which he agreed to the proposal. After completing the necessary requirements and submitting requisite documents, the jurisdictional registrar of the company sanctioned and registered the above named company by issuing the certificate of incorporation. Utkarsh, the company satisfactorily produced, distributed, and supplied the generic medicine constantly during the span of 7 years. By this time, the company had a grand team of medical representatives, distributors, and retailers who built and transformed business by customizing market. In order to keep pace with the changing technology, growing production, and business opportunities, Utkarsh, along with his wife Divya, is willing to convert Utkarsh Pharmaceutical Private Limited, one person company, into a private limited company. On the other side, his brother Yashwant, nominee in Utkarsh Pharmaceutical Limited, one person company, also started his own hospital along with Raghu, a renowned medical practitioner, by incorporating a private limited company, namely Vinayak Multi Care Hospital Private Limited, with an authorized share capital of 10 crores and paid up share capital of 5 crores, having its registered office at Savarkar Place, Pune. The total number of shareholders in this company is 60, of which three shareholders are in the employment of the company, whereas other two shareholders who purchased the shares of the company while in employment of the same company left the company before 6 months. Admiring the success of Utkarsh Pharmaceuticals, Yashwant requested his brother Utkarsh to be a director production, but Utkarsh went to carry out non-banking financial activities, including investment in securities of body corporates. Based on the facts of the scenario given above, choose the best appropriate answer to the following multiple choice questions based on the provisions of the Companies Act 2013. Yashwant, the elder brother of Utkarsh, agreed to become nominee in his Utkarsh Pharmaceutical Private Limited, one person company. Which of the following regarding the formalities must be completed by Utkarsh while making Yashwant nominee? So, Utkarsh must have obtained a written consent letter from Yashwant and stated his name as a nominee in the memorandum of association under nominee clause. Yes, it should be written consent and you should be in memorandum of association under nomination clause. It is not articles of association. It is not either memorandum or articles of association, since there is no such requirement, and it is not. So within the 15 days after incorporation must be kept in records maintained with this office. Not required. So the correct answer is A, where there should be written consent from the Yashwant and stated his name as a nominee in memorandum of association under nomination clause. Moving on, the second question is, it is clear from the case scenario that Yashwant has formed Vinayak Multicare Hospital Private Limited with 60 shareholders, of which two shareholders are ex-employees and the other three are still the employees of the company. Which of the following is correct option relating to maximum shareholders to whom the shares may be allotted in the company? So, Vinayak Multicare Hospital Private Limited can issue a shares to maximum 150 persons. Option A. Option B. Vinayak Multicare Hospital Private Limited can issue a shares to maximum 140 persons. Option C. Vinayak Multicare Hospital Private Limited can issue shares to maximum 155 persons. This is the correct. And the third D option is Vinayak Multicare Hospital can issue shares to maximum 90 persons. So they can go up to maximum 155 persons. Whether Woodcourse, the third question is whether Woodcourse, the owner of Woodcourse Pharmaceutical Private Limited, one person company, can carry out non banking investment activities during the investment in securities of any body corporate. So, the correct answer is Woodcourse, the owner of the one man company, cannot undertake carrying out non banking financial investment activities, including the investment in securities of any body corporate, irrespective of the quantum of its paid up share capital. So, this is not possible. That is the reason option D is correct. Vinayak, the question number 4. Vinayak Multicare Hospitals is incorporated as a private company with 60 shareholders, 5 employee shareholders. For determining if it breaches the statutory limit on the number of members in a private company, how should be company shareholders be counted under the Companies Act 2013? Only the shareholders who are not employees are counted, because employee shareholders are excluded always. Please remember this. This is very critical. Any question is possible in the examination on this. Moving on, case scenario 2. ABC Solutions LLP, registered under the Limited Liability Partnership Act 2008, operates a software consultancy firm based in the Punjab with two partners, Mr. Rex A as the designated partner and Mr. Y. The LLP agreement requires 30 days notice for registration, but Mr. Y skips notice to Mr. X and the form and unilaterally files Form 6 with the Register of Companies in January 2026, imitating cessation of his partnership interest with immediate effect. The LLP fails to file the mandatory Form 4 with the registrar within the prescribed time period, attracting a penalty of 100 rupees per day for each designated partner. Mr. X, having knowledge of Mr. Y's cessation since Jan 2026, continues to run the business as the sole remaining partner, enters into a new client contracts and incurs a supplier debt amounting to 50 lakhs over the next 8 months without admitting any new partner. Suppliers now pursue recovery from Mr. X's personal assets, including his family home in Ludhiana, claiming that LLP, limited liability shield, no longer applies. So, on the basis of above facts and by applying the applicable provisions of the Limited Liability Partnership Act 2008, the applicable rules therein choose the correct answers 1 out of 4 of the following multiple choice questions given here under. Under the Limited Liability Partnership Act 2006, what is the general sequence when LLP is reduced to only one partner because the other partners leaves and no new partner is admitted within the prescribed period? The correct answer is the LLP and remaining partners may continue temporarily, but the remaining partners can become personally liable if the new partner is not admitted within statutory period. So this is very critical because they personally liable unless if new partner is not admitted within the statutory period. The following question: if the LLP continues business with only one partner beyond the statutory grace period without admitting the new partner, what is the typical nature of remaining partners' liability for obligations incurred during that default period under the Act? So the correct answer is the remaining partners may be held personally liable, similar to the partner in a traditional unlimited liability partnership for the obligations incurred during the non-compliant period. So they are still liable, and in addition to the traditional in same similar to the traditional unlimited liability partnership, so they cannot escape their liability and they are still liable. Following question: assume Mr. Y has resigned from ABC Solutions LLP and his cessation has been duly filed and recorded. A creditor supplies goods 2 months later, relying on old statutory still showing Mr. Y as partner. What is the most likely legal position of Mr. Y regarding these new debts? Mr. Y has no liability because he validly ceased to be a partner and proper notice was given. Since proper notice was given, Mr. Y has no liability and he validly ceased to be a partner. So the following question is: can supplier proceed against Mr. X personal property for recovery of 50 lakhs? Yes, absolutely. So the following MCQ is: XYZ Limited is a company with 51% of its equity shares held by the state government of Maharashtra and 49% by private investors. The board of XYZ Limited seeks to appoint an auditor for the upcoming financial year. As per the Companies Act 2013, the following statements is correct regarding the appointment of auditor. So the Controller and Auditor General CAG of India will appoint auditors for XYZ Limited. Yes. You can see here 51% of equity shares held by the state government Maharashtra. So CAG has the power to appoint the auditor. The following MCQ: a listed company has a net worth of 480 crores, turnover of 1200 crores, and net profit of 3 crores in the immediately preceding financial year. How does CSR provisions apply to this company? CSR provisions applicable because it satisfies the turnover threshold, because the turnover here is 1200 crores, even though the net worth and net profit thresholds are not met. So you should just remember the turnover. Let's see the following question. This is the descriptive questions. XYZ Limited is a prospective to raise funds for a new manufacturing projects. After successfully raising the fund, the company identified an investment opportunity in a different industry 6 months later, requiring a significant portion of the funds. The proposed investments involved trading in equity shares of other listed companies. The board of directors suggested varying the original objectives for which the funds were raised to allow this new investment and recommended passing a special resolution in company's general meeting. While the promoters and controlling shareholders supported this change, some shareholders expressed concerns, particularly regarding the deviation from the initially stated purpose of the funds. Based on the provisions of the Companies Act 2013, advise on the validity of the proposal to redirect the funds toward this new investment. So, for this new investment, let's see. According to the section, just see the framing of the answer. First, we are quoting the section number. So this is where the first impression for the examiner to give the marks to you. 27 subsection 1 of the Companies Act 2013. The terms of the contract referred to in prosperous are subject for which the prospectus has been issued can be varied, but only with the authority of the company given by it in general meeting by way of special resolution. The second proviso to the subsection 1 prescribes that such company is not to use any amount raised by its through the prospectus for buying, trading, otherwise dealing in equity shares of other listed company. The given question, XYZ Limited is planning to use the amount initially raised for investing in the different industry, which also involves trading in equity shares of other listed companies. Though XYZ Limited has passed the resolution for the said proposal, but it cannot use any amount raised by it through the prospectus for buying, trading, or otherwise dealing in the equity shares of any other listed company. Hence, the said proposal for new investment is not valid. So, please remember the section and 27 subsection 1, and this describes they cannot use it. It is invalid. So, this kind of question definitely possible in the question this time, because this is very important. Most of the companies will not follow this sometimes, and they will be punishable under this section. So, following question: John Private Limited is an unlisted company incorporated in the year 2020 2012. The company have share capital of rupees 50 crores. The company has decided to issue sweat equity shares to its directors and employees. The company decided to issue 10% equity, sweat equity shares, which in total will be add up to 30% of its paid up capital, equity capital, with a locking period of 5 years. As it is a short, startup company, explain the provisions of for issue of sweat equity shares by the startup company with reference to the provisions of Companies Act 2013. So we just need some provisions to explain this. Let's see the answer. Sweat equity shares is governed by the section 54 of the Companies Act. If you remember, please quote the section. Otherwise, as per the provisions of the Companies Act 2013, at least mention this. That is the significance for allotting the marks. And the Rule 8 of the Companies Act, Share Capital and Debentures Rule 2014, according to the Section 50, where the company can issue the sweat equity shares to its directors and permanent employees of the company. According to the Rule 8, Subsection 4 proviso, a startup company, as defined by the Ministry of Commerce and Industry, Government of India, many issue sweat equity shares not exceeding 50% of its paid up share capital up to 10 years from date of its incorporation or registration. According to Rule 8, subsection 5, sweat equity shares issued to the directors or employees shall be locked in non-transferable for a period of 3 years from the date of allotment, and the fact that the share certificates are under lock-in too. Hence, in the above case, the company can issue sweat equity shares by passing special resolution at its general meeting. The company, as a startup company, is the right in issue of 10% sweat equity shares as it is overall within the limit of 50% of its paid up share capital. But the lock-in period of the shares is limited to maximum 3 years period from the allotment. So please remember, lock-in is 3 years. At the same time, it is non-transferable within the 3 years, and it cannot exceed 50% of the paid up capital. Equity shares up to 10 years from the date of incorporation of our registration. So these provisions you just need to mention so that you will get the full marks for this question. So sections are important. Whenever you quote the sections, you will get the full marks. RS Limited received a share application money 50 lakhs on 1st Jan 2025, but the failed to allot shares within the prescribed time period. The share application money of 5 lakhs received from Mr. Khanna, a customer of the company, was refunded by the way of book adjustment towards the dues payable by him to the company on 30 30th July 2025, the company secretary of RS Limited reported to the board that the entire amount of 50 lakhs shall be deemed to be deposited as on 31st July 2025, and the company is required to comply with the provisions of the Companies Act 2013 applicable to the acceptance of deposit in relation to this amount. You are required to examine the validity of the reporting of the company secretaries in the light of the relevant provisions of the Companies Act 2013. Okay, so this is the provisions compliance governance related question. Let's see the answer. According to the rule 213, 2 clause 1 subsection 3 of the Companies Act acceptance of deposit rule. So this is the way you need to clearly mention the provision, whatever is applicable here. The following category of the receipt is not considered as a deposit. Any amount received or held pursuant to an offer made in accordance with the provisions of the Companies Act 2013 towards the subscription to any securities, including the share applicable money, application money, or advance towards the allotment of securities pending allotments, or as long as such amount is appropriated only against the amount due on allotment of securities applied for. It is clarified by way of explanation that if the securities for which application money or advance for such a securities was received cannot be allotted within 60 days from the date of receipt. Please note this point also. Within 60 days from the date of receipt of application money or advance of such securities, such application money or advance is not refunded to the subscribers within 15 days. Within 15 from the date of completion of 16 days. So within 15 days from the date of completion of 16 days, such amount shall be treated as a deposit under these rules. Further, it is clarified that any adjustment of amount for any other purpose shall not be treated as refund. In the given case, RS Limited has received 50 lakh as share application money on 1st June 2025. It failed to allot shares within the prescribed limit. Further, on 30th July 2025, the company adjusted the amount of 5 lakhs received from Mr. Khanna as a customer of the company by way of book adjustments, the dues payable by him to the company. So, in the light of the facts of the question and provisions of the law, if such application money or advance is not refunded to the subscribers within 15 days from the date of completion of 60 days, as such amount shall be treated as a deposit. Yes, in the question, the prescribed limit of 60 days will end on 31st July 2025, and the company has 15 more days to refund such application money to the subscribers. Otherwise, after lapse of such 15 days, the amount not so refunded will be treated as a deposit. Hence, the company secretary of RS Limited is not correct in treating the entire amount of 50 lakhs as deposit on 31st July 2025. Any adjustment of amount for any other purpose shall not be treated as refund. Thus, the amount of 5 lakhs adjusted against the payment due to be received from Khanna cannot be treated as refund. Please note down, my friends. This is not a refund because this is about settlement. They adjusted against the some debts, right? This is not the case. Please note, this is very important question. There is a possibility that it may come, same question also may come in the examination, right? So yeah, so let's go for the next question. PQR Limited and manufacturing company in the process of expanding its operations. To support its expansion, PQR Limited has acquired a plot of land along with the building on its from ABC Limited, another company in the same industry. The property, however, is subject to an existing charge created in favor of bank security for a loan taken by ABC Limited. This charge has been registered by ABC Limited at that time. The directors of PQR Limited are of the opinion that as the charge for the property was already created, there is no further obligation to be fulfilled from the side of PQR Limited. After negotiation, the bank as the charge holder consent to the sale and transfer of the property to PQR Limited with the condition that PQR Limited must register a new charge over the acquired property as security for its own loan obligation. Advise whether the contention of the directors of PQR Limited is correct. Give your answer in terms of provisions of the Companies Act 2013. So, this is a very important question. Let's see. So, your answer always start with the respective provisions, quoting the respective provisions of the Act. So the provisions of section 77 relating the registration of charges shall so far may be applied to a company acquiring any property subject to a charge within the meaning of the section, or any modification in terms or conditions or extent or the operation of any charge registered under that section. According to the Section 79A of the Companies Act 2013, in case of any property where charge is already registered and if it is sold with the permission of the holder of the charge, it shall be the duty of the company acquiring it to get charge registered in accordance with Section 50, Section 77. So, according to the provisions of the Section 77, when a company acquires property that is subject to an existing charge, it is the duty of the acquiring company, PQR Limited in this case, to register the charge as its own. This means that PQR Limited must create a fresh charge over the acquired property and register it with the Register of Companies ROC as per the Section 77. Now, upon the acquisition, it is a PQR Limited's responsibility to ensure that the provisions charge is effectively discharged and the new charge is registered in its name, reflecting PQR Limited as the current owner and debtors of the charge. Hence, contention of the directors of PQR Limited that since the charge of the property was already created, there is no further obligation on part of PQR Limited. It is not correct. So since the charge is created, PQR Limited is the current owner and is already registered in its name, reflecting PQR Limited has the current owner and debtors of the charge. So there is no further obligation on part of PQR Limited and it is not correct. So this is possible question, my friend. Section number, please remember, which is charges registration, section 77, and you need to quote along with the section 79A as well in case of property charge applicable here, already registered. It is sold with the permission of the holder of charge. So these are the sections you need to quote immediately so that the immediate impact you can see in allotting the marks. Discuss the following in light of the provisions of the Companies Act 2013. Mr. Prem and his wife, Mrs. Achana, jointly hold shares of the ABC Limited in a dematerialized demat account form. In such circumstances, which of the joint holders is entitled to exercise the voting rights through the e-voting facility? Okay. Annual general meeting of the company is scheduled to be convened on 10th September 2025. Determines the duration of the remote e-voting period and specify the time at which such e-voting shall conclude. So this is important question. It also can repeat in the exam. So the answer is the joint shareholders must concur in voting unless the articles provide to the contrary. The voting in case of joint holders is done in the order of seniority, which is determined on the basis of the order in which their name appear in the register of members shareholders. The joint holders have a right to instruct the company as to the order in which their names are to appear in the register. As per the Rule 21 of the Companies Management and Administrative Rule 2014, the scrutinizer shall arrange for polling papers and distribute them to the members and proxies present at the meeting. In case of joint shareholders, The polling paper shall be given to the first named holder or in the absence to the joint holder attending the meeting as appearing in the chronological order in the folio. Thus, in the given case, Prem or his wife, Mrs. Archana, whosoever name appears first in the chronological order in the register of the members, shareholder shall be entitled to vote. Time period for voting. The facility for remote e-voting shall remain open for not less than 3 days and shall close at the 5 p.m. on 5 p.m. on the date preceding the date of the general meeting. Thus, the annual general meeting is going to be held on 10th September 2025. The facility for remote e-voting shall open on 7th September 2025 and close on 5 p.m. on 9th September 2025. So please be careful about the timings here and the sections and provisions of the act, so that if you want to answer, get the full marks, you need to answer this in full extent. Let's go to the next question, question number 16. Prime Industries Limited, a public limited company with 800 members, convened its general meeting at 11 a.m. on 15th March 2027. The Articles of Association do not prescribe a higher quorum. At the meeting, the following individuals are present: Rahul Sharma, Priya Patel, and Vikram Sinha, three individual members present in person. Arjun Mehta, authorized by Horizon Private Limited, a corporate member, through a board resolution to present it. Neha Kapoor, submitted authorized by Summit Limited, another corporate member, through a broad resolution, board resolution to represent it. That's all. Karan Desai, Maya Reddy, two individual members present only by proxy. Okay. Arun Mehta arrives at 11:15 a.m. Discuss the quorum requirements as per the provisions of Companies Act 2013, addressing whether quorum is met at the start and during the meeting, whether the meeting will deemed to be validly conducted if Arjun Mehta arrived at the meeting at 11:15 a.m. So the problem here is the timelines, exact timelines. What is it as per the legal provisions, or is it a violation or not? So we need to prescribe the provisions of the act clearly with the details. Let's see the answer for this. So the way you need to write always with the sections of the act. So as per the provisions of 103 of the Companies Act 2013, unless articles company provide the larger number, the quorum for the meeting of the public limited company shall be 5 members personally present. If number of members is members are not more than 1,000. Okay. Rahul Sharma, a Priya Patil, Vikram Sinha will be counted as a 3 members. The company is a member of another company. It may authorize a person by resolution to act as its representative at the meeting of the latter company. Then such a company shall be deemed to be a member present in person and counted for the purpose of quorum. Hence, Arjun Mehta and Neha Kapoor, representing Horizon Limited and authorized by the Summit Limited, respectively, will be counted as 2 members. Only members present in the person and not by proxy are to be counted. Hence, proxies, whether they are members or not, will have to be excluded from the purpose of quorum. Those Karan Desai and Maya Reddy will not be counted in the quorum. In the light of the provisions of the Act and facts of the question, it can be conducted that quorum of general meeting of Prime Industries Limited is 5 members personally present. The total 5 members were present. The requirement of the quorum fulfilled. Right. So proxies are not counted, and whatever that individual form of entities attended, they'll come counted as a each person. So total 3 plus 2, 5, so that it happened correctly. So the second point here is the section further states that if the required quorum is not present within the half an hour, the meeting shall stand adjourned for the next week at the same time, and the place are such other time and place as decided by the board of directors. Since Arjun Mehta is an essential part of the meeting, the quorum requirement, and he reaches at 11:15 a.m., that is within half an hour of the starting of the meeting will be valid. Half an hour of the starting of the meeting. Please note this minute things. This makes the marks. Okay, move on to the next question. 17. Limited Liability Partnership Act 2008. Pride Consultants LLP is facing the temporary financial difficulties and proposes a compromise with its unsecured creditors for the payment of 70% of its outstanding dues in full settlement. An application is made before tribal tribunal by one of the partners of the LLP seeking directors to convene a meeting of creditors. The tribunal orders the meeting to be held. At the meeting, creditors representing 70% in value of the total outstanding debt vote in favor of the proposed compromise. The LLP thereafter approaches the tribunal for sanction of the scheme. However, the LLP fails to disclose in its application that an investigation proceedings is pending against it under the Limited Liability Partnership Act 2008. After obtaining the tribunal sanction order, the LLP does not file the order with registrar within 30 days. A dissenting creditor challenges the validity of compromise on these grounds. Examined as per the provisions of Limited Liability Partnership Act 2008, whether the compromise can be sanctioned by the tribunal despite non-disclosure of pending investigation proceedings, whether the compromise becomes effective and binding if the tribunal order is not filled with the registrar within prescribed time. So, LLP Act should be aware to answer this question correctly. According to the Section 20 of the Limited Liability Partnership Act 2008, if a majority representing 3/4 in value of the creditors or partners, as the case may be, at the meeting agreed to any compromise or arrangements, the compromise or arrangement shall, if sanctioned by the tribunal, by order be binding on all creditors or all partners, as the case may be, and also on limited liability partnership, or in the case of limited liability partnership which is being wound up on the liquidation and contributories of limited liability partnership, provided that no order sanctioning any compromise or arrangement shall be made by the tribunal unless tribunal is satisfied that limited liability partnership or any other person by whom an application has been made as disclosed to the tribunal, any by affidavit or otherwise, all material facts relating to the limited liability partnership, including the latest financial position of the limited liability partnership and the pendency of any investigation proceedings in relation to the limited liability partnership. An order made by the tribunal shall be filed by the limited liability partnership with the registrar within 30 days. Please note this. After making such order, and shall have effect only after it is so filled. In present case, Bright Consultants LLP failed to disclose the pendency of investigation proceedings. Such disclosure is mandatory. Therefore, tribunal cannot validly sanction compromise unless full and true disclosure of material facts is made. The objection raised by the dissenting creditors is legally sustainable. The tribunal cannot sanction the compromise without disclosure of material facts, including the pending investigation. In this case, LLP failed to file the order within 30 days. So LLP failed to file the order within 30 days. Accordingly, even if the tribunal sanctions the compromise, it will not become effective or binding until the order is duly filed with registrar. The compromise does not take effect unless the tribunal order is filed with the registrar within 30 days. So please note this, the time limits are 30 days and it has to be filed within the days, otherwise it is not valid. And the consultancy LLP is not followed the required procedure. So let's go to the General Clause Act 1897. The National Infrastructure Authority Act 2005, a central act enacted after commencement of the General Clause Act 1897, provides that a chairperson of the National Infrastructure Authority shall have the power to grant licenses for strategic highway projects. In 2024, the resignation of chairperson was replaced by managing director through an amendment to the Parent Act. The powers and functions earlier exercised by the chairperson were formally vested in managing director. A dispute arose when a company challenged the validity of license granted by the managing director on the ground that original provisions of the act referred to the chairman and not to the managing director. The company contended that since the act specifically mentions chairperson, only that office holder could exercise the power, not any success authority. The reference to the provisions of the General Clause Act 1897 relating to the successors examine whether the license granted by the managing director is valid. So we need to cross check the provisions. So the answer for this question is see, according to the section 17 of the General Clause Act 1897, in any central act or regulatory made after commencement of this act, it shall be sufficient for the purpose of indicating the application of law to every person or member of the person for the time being executed the functions of the office. To mention the official title of the officer at present executing functions or that of officer by whom the functions are commonly executed. According to the section 18 of General Clauses Act 1897, in any central act or regulations made after commencement of this act, it shall be sufficient for the purpose of indicating the relation of the law to the successors of any functionaries or of corporations having the perpetual succession, to express its relation to the functionaries or corporations. At the present case, National Infrastructure Authority Act 2005 is a central act enacted after commencement of the General Clauses Act 1897. The act originally preferred answers on the chairperson. Subsequently, a designation was challenged to managing directors. The same powers were vested in the new office. By virtue of the provisions of General Clause Act 1897, the reference to the chairperson include the successor office now designated as managing director. Therefore, the license granted by the managing director illegally valid and company's contention is untenable. So just the provisions of act, if you don't even remember, then mention according to the provisions of General Clause Act 1897 and mention that according to referred, the power chairperson subsequently designated was changed to managing director and the same powers were vested in the new office. So mention that with reference to provision, chairperson include the successor office now designated managing director. So legally valid. Just mention clearly the provisions, even if you don't remember exact section, just refer the closing. What is exactly your interpretation? Moving on, question number 9, interpretation of statutes. Central government enacted the Industrial Regulation Act 1985. One of the provisions of the act uses the term processing unit, but the term is not specifically defined in statute. For the last 30 years, licensing authorities across the country have consistently treated small packaging units as processing units. Under the Act, several industries have been granted licenses on this basis. The legislation has amended the Act multiple times over the years, but has never altered the interpretation. Further, in one case, High Court also accepted this long-standing practice while deciding a dispute. Recently, a new regulatory authority has taken a different view and denied license to the packaging unit, arguing that the term processing unit shall be interpreted strictly as per its discretionary meaning and not according to the past administrative practice. The affected company challenges the decision and contends that long standing language and practice should guide the interpretation of the statute. While interpreting the statute, what is the effect of usage, customs, and long standing practices? Explain with reference to the relevant principles and Latin maxims. Okay, so the question number 19. So, effect of usage. Usage or practice developed under the statute is indicative of the meaning recognized to its words by the contemporary opinion. A uniform monoritous practice continued under the old statute and inaction of the legislature to amend the same are important factors to show that practice so followed was based on the correct understanding of the law. When the usage or practice receives judicial or legislative approval, it gains additional weight. In this connection, we have to hear in mind two Latin maxims: optima legum interpres est consudis. The custom is the best interpretation of law, and contemporanea exposito est optima est and frontinia e lege. The best way to interpret document is to read it as it would have been read when made. Okay. Therefore, the best interpretation and construction of the statute or any other document is that which has been made by contemporary authority. Simply stated, old statutes and documents shall be interpreted as they have been at the time when they were enacted or written. Contemporary official statement throwing light on the construction of the statute or statutory instruments made under this has been used a contemporanea exponio to interpret not only the ancient but even the recent statutes in India. Therefore, in the given case, the long-standing and uniform administrative practice supported by the legislative inaction and judicial approval would carry significant persuasion value in interpreting the term processing unit. My dear friends, it is a just generic thing where you need to remember the clause and just explain that. That's all. So it's a memory based understanding question where you need to answer. Let's see the last question in the RTP for May 2026 examination. The Foreign Exchange Management Act 1999. The Golden Global Limited is a company incorporated and registered in the Germany. On 1st April 2012, it established a branch office at Chennai, India. The Chennai branch subsequently began controlling the operations of the another branch of Golden Global Limited situated in Dubai. With reference to the provisions of the Foreign Exchange Management Act 1999, determine the residential status of Golden Global Limited, the Chennai branch, Dubai branch controlled by the Chennai branch. So, with reference to the question, they are very clear that in terms of execution, according to the Section 2U of Foreign Exchange Management Act 1999, FEMA, person includes same company and any agency, office, or branch owned or controlled by such office. Section 2(5), subsection 4(5) defines a person resident in India. As per this definition, the following shall be included in the definition of person resident in India: any person or body incorporated, registered, or incorporated in India, an office branch or agency in India owned or controlled by a person resident outside India. An office, branch, or agency outside India owned or controlled by the person resident in India. So, as per the facts of the question of provisions of the Act, Golden Global Limited as well as Chennai branch of Golden Global Limited is a person. Golden Global Limited foreign company does not fall under any of the clauses of definition of person resident in India. Therefore, Golden Global Limited is a person resident outside India. Chennai branch of Global is a person resident in India since it falls under the clause an office, a branch or agency India owned or controlled by the person resident outside India. So the Dubai branch of Global Golden Global Limited, though not owned, is controlled by the Chennai branch. The Dubai branch is a person resident in India since it falls under the clause an office, branch, or agency outside India owned or controlled by a person resident in India. So these are the standard clauses where we define the person and control for person resident in India. With this definition, when you are aware about the ABC, you can define that resident who is control, who is non-resident. So these are important questions. Just remember, practice, and these questions exactly also may come in exam, and it may come in different forms, different names, but context may be the same. So just practice. If you have the command on these questions and answers, you will maximum get some marks out of these RTP. Some questions may repeat, and whatever amendments mentioned here are very important for your preparation. Please go through multiple times all these amendments and the MCQs